Hello friends, today we will discuss a very interesting case on the issue of notice under section 148 and the service of notice under section 148. There is always a confusion that if the notice has been issued and if it is not served on the assessee, or if the notice is issued but not in a manner which is given in the statute, then whether that notice will be a valid notice or not. This issue has been taken by Honorable Gujarat High Court in the case of ISHWARBHAI, THAKORBHAI Patel versus Income Tax Officer, and this case is reported in 467 ITR at page number 558. The date of the judgment is 1st January 2024. The facts of the case are very interesting. In the present case, the assessee sold an agriculture land and the assessee was not having any PAN number. The assessing officer, in order to tax the transaction, issued a notice under section 148 at the address at which the agriculture land of the assessee was registered, meaning thereby that this notice was not sent to the assessee on his residential address, although the residential address was also mentioned in the sale deed of the agriculture land. The assessee got to know about this notice from other sources, and when the assessee got to know about this notice, the assessee challenged and filed the objection before the learned assessing officer that this notice has not been served on the assessee at his address, and since the assessee has got this notice from other sources, so this is not a valid notice and it should be quashed. But the assessing officer disposed of the objections of the assessee by not accepting the objections of the assessee and said that it is a valid notice. When this matter was before the Gujarat High Court through a writ petition, the court said that in the present case, the notice has not been served at the residential address. So, in the present case, the assessee can be said to have never received the notice. The court said that in the present case, the order disposing of the objections of the assessee should be set aside. In the present case, the court said that although there is no doubt that the notice has been served, but it was on a wrong address, so it was not a valid service of notice. The court said that the service of the notice is not a procedural requirement. The court said that the notice should be served either on the assessee or his authorized representative, and it is a condition precedent for completing the assessment under section 147. The Honorable Court was of the view that the service of the notice is a jurisdictional requirement. The court elaborated that if the statute says that the notice is to be served in a particular mode, then even if the notice is served but by not a mode which is specified in the act, then it will not be a valid service of notice. The court said that Order 5, Rule 12 of the Civil Procedure Code applies for the service of the notice, and simultaneously the Order 3rd, Rule 6 of the Civil Procedure Code also applies. The court further said that the burden of proof that the notice has been served on the assessee is on the revenue. The court said that the date of signing of the issue, the date of signing of the notice is not important, and the date of issue will be considered that date at which the notice is handed over to the postal officer for service of the notice. The court said that until and unless the envelopes are properly stamped, in which the notice is to be sent with adequate stamp value by the postal officer, until up to that, it cannot be said that the process of issue is complete. So, in the present case, since the notice has not been served on the assessee at his residential address up to the date of the limitation period prescribed under section 149, so the notice is not valid and the court quashed the proceedings. At the end of this video, once again I am repeating the name of the case. The name of the case is ISHWARBHAI THAKORBHAI Patel versus Income Tax Officer, and this case is reported in 467 ITR at page number 558, and the date of the judgment is 1st January 2024. Thank you, friends.